report which is submitted before the court in the court after the completion of the investigation. And whenever we hear about the report, automatically it comes to our mind that it is about charge sheet. But be clear about this, it is not always the charge sheet. The general perception is this, whenever a report is submitted in the court, that is the charge sheet. Okay. So this report is a very detailed report. The name of the accused and the witnesses and the incident, etc., etc. All the details are given in this report. Okay. It may be charge sheet or final report, which is commonly known as closure report. But in both cases, the report has to be submitted. If certain case is made out, the same report becomes the charge sheet. If the case is not made out means if the investigating officer does not find anything in that case, it becomes a final report. Okay. This report, there is a procedure for the submission of this report. What is that procedure? This report is submitted through a senior police officer. The case is not like this, the investigating officer directly submits the report or may submit the report in the court. No. The investigating officer first gives that report to the officer in charge of the police station. If the officer in charge of the police station himself is not the investigating officer, and that officer in charge of the police station will send that report to some senior police officer. And by that senior police officer, the report comes to the court. Okay. Now, before coming to the court, what happens in the court when report reached before the court is submitted in the court, and why this provision is there by virtue of section 158 that a report is submitted through a senior police officer. The reason is in subclause 3 of section 173, this senior police officer has the power to send this report back to the investigating officer and can ask for the further investigation. If this police officer thinks that this investigation has not been done properly, or this investigation, this case is further required some investigation, this is the power of that senior police officer. He can send it back to the investigating officer. And what it is the practical value of this? In many cases, in the cases of influential person, this power is used. Okay. Sometimes the report is sent back by the senior police officer, and it is very interesting. Suppose the investigating officer has given a certain result, for example, result A. But when the senior police officer send it back to the investigating officer, the second result of that investigation may becomes B instead of A. You get this point? It is entirely changed. And I need not to discuss all those things. You are intelligent enough. Why It happens, and sometime it happens. The logic of this power of senior police officer is sometimes it happens that, and it may have been considered by the legislature that the investigating officer may have committed certain mistake, may not have performed his duty properly. There may be anything. For the correction of that, this power is given to the senior police officer. That the senior police officer may send that report back to the investigating officer. Okay, but how is it is used, and what is its practical value? What happens in practice? That is altogether different thing. But this is the procedure. Now, police report finally comes before the court. Now, there are two important points which are to be discussed with you. Other things you will read under section 173, and there is nothing technical in all those things. The point number one: suppose the investigating officer has investigated the case and finally submit the report in the court through senior police officer, but somehow, for any reason whatsoever, though the report has already been submitted, but some new facts regarding that criminal case which was investigated by that investigating officer, some new facts appears or comes in his knowledge relating to that case. Now the question is, once the police report or the charge sheet is submitted before the court, in that case, has that investigating officer any power to reinvestigate that case or to further investigate that case? The answer is yes. Even after submission of the police report, charge sheet, if investigating officer thinks it or investigate that same case further, he can investigate by virtue of subclause 8 of section 173. And he may further send the charge sheet or the report charge sheet, further send the charge sheet which is known as supplementary charge sheet. And it happens, supplementary charge sheets are also sent by the investigating officer in the court. Okay. Second point is that now the investigation is over and the finally report charge sheet is submitted before the court. Now the question is, what court can do? What court can do means whether it is mandatory for the court to accept that charge sheet as it is, or whether court has certain power, or what the court can do. If somebody asks us, according to law, the charge sheet is submitted Now the court should accept that charge sheet. Okay. And the should take the cognizance of the case, and after the cognizance the trial will start. Normally it is our perception. It comes to our mind. The court cannot do anything at the point of submission of the charge sheet. It is our perception. But it is not true. Court is not bound to accept the charge sheet. It is altogether different thing. Generally, court accept the charge sheet as it is. It is the matter of practice. But so far as the law is concerned, the court is not bound to accept the charge sheet. Do you get this point? Any question up to here? Any question up to here?
No, sir.
Yeah?
No, sir.
Okay. Now, if court is not bound to accept that report as it is, now obviously the second question is, what court can do? Court can ask to the investigating officer for further investigation before accepting this charge sheet. For re-investigation, not the further investigation. It may be the further investigation or also re-investigation. How? By virtue of which section? Yes, please come. You will tell yourself. We have already discussed that. Yes, please. Section 156, subclause 3. It is very clear. There is an option. The court may either accept that report as it is. Okay, accept it. And the further proceeding will start. The proceeding of cognizance and trial, etc., etc. And the second option is court may think out, okay, oh no, we are not going to accept this report. We are not satisfied by this report. The court may order for further investigation by virtue of section 156 clause 3. Okay, and it is very important to know that after the submission of the report, of course the court can ask for the reinvestigation, but during the investigation, it is very important. During the investigation, court has no power to interfere in investigation. What does interference means? Interference means the court cannot ask the investigating officer to do investigation in this direction or in that direction. So far investigation is concerned, the investigating officer has independent, full power for investigation. Nobody can interfere in the investigation. even the court. Sometimes it is the misconception that the court can interfere in the investigation, but the court cannot interfere in the investigation. Court cannot ask or cannot say to the investigating officer to do the investigation by this method or in this way or that way, in this direction or that direction. This X is not should not be an accused. Y should be an accused, etc., etc. No instruction, right? But when once the investigation is completed, then the court has the power. If the court is not satisfied, the court has the power to set it for re-investigation by virtue of section 156 clause 3. Okay. But there is a third situation. What we discuss about the investigating officer, about the court, etc., etc. But we didn't discuss about the parties. Party means in criminal cases generally party may be victim, accused. Now the question is, if somehow parties are not satisfied, or the victim or the accused or anybody is not satisfied with the investigation, in that case, does he have any power?
So protest petition.
Protest petition. But it is very interesting, very, very interesting, and that is the reason to discuss with you here. Okay, this provision of protest petition is not provided under section 173. If somebody is not satisfied with the investigation, he may file the protest petition. It's okay. Absolutely correct. But it is not given in the CRPC. This concept was developed by virtue of the various rulings given in various cases. Rulings of higher courts. For example, the Ram Iqbal Pandey versus Kapil Dev case, Irta versus R. Pandit, it is Karnataka High Court case. There are so many cases. The higher court developed this concept that if somebody is not satisfied with the investigation, he may file the protest petition against that investigation, and the court will hear that person and will take action accordingly. The court will take action accordingly. Okay. And that is the different thing. And that is the reason, because of this provision of protest petition, when the report is submitted before the court, it is obligatory. The court has to provide an opportunity to the concerned party to hear the concerned party. And it is different thing in how many cases the protest petitions are filed, and in how many cases the court actually take the action on protest petition. It is different thing, but the protest petition can be filed, right? You may have heard about the Arushi case, Noida Arushi case of it happened in 2008. What happened in Arushi case? The first, when this incident occurred, in the beginning, the UP police was investigating this case. And very unfortunate, or the mishappening was done to this case, that the crime scene was disturbed by the media person and neighbors. So many media person and neighbors reached to the crime scene in that room, and because of that, all the evidences, because the finger uh, in that room, I think 25 and 26 fingerprints were taken by the police. And all the fingerprints and other things were not clear, and that was because of the crime scene was drastically disturbed. Anyway, that is a different thing. What happened in this case? The investigating agency could not find anything. And investigating agency was finally to close the case. Investigating agency submitted a final report, not the charge sheet. Investigating agency was of the view that we have got nothing in this case. Though it was a very infamous case, every time it was in media, print media, or all the media, it got a big coverage. Even then, and the murder, of course, Arushi was murdered. Two persons were murdered, Arushi and Hemraj, their servant. Two persons were murdered, and investigating agency was of the view that we have got nothing in this case. Okay. And this final report was submitted in the court. But the Mr. and Mrs. Talwar, who were her parents, who were Arushi parents, were not satisfied with this report, this final report. They filed a protest petition in the court that we are not satisfied with the report of investigating agency. That was the CBI. It was initially investigated by the UP police, or the investigation was taken from UP police. It was given to the CBI, and the third time it was again given to the second team of the CBI. The case was transferred thrice to different investigating officers. So they filed a protest petition. Court entertained their petition and asked for the other investigating officer of the CBI to reinvestigate the case. One CBI team has submitted this report. They filed the protest petition that we are not satisfied with this report. The court entertained their petition and handed over this same case to the other team, other team of the CBI. Why it was given to the other team? Because they were not satisfied with the report of first team. Other team investigated the case. And it is very interesting. Other team made the accused, made the Mr. and Mrs. Talwar as accused. Made the accused those persons who filed the protest petition. Mr. and Mrs. Talwar were not satisfied, therefore they filed the protest petition. Their protest petition was accepted. The case was handed over other investigating team, and that team, the second team, investigated the case. And what did the second team find? It found that the Mr. Rajesh Talwar and Mrs. Rajesh Talwar committed the murder of Arushi. Murder of their own daughter. Okay. So, what is in the hands of the court? After entertaining the protest petition, court can only do the thing, or court can only enable the reinvestigation. But as I told you, the court has no power to direct the investigating agency, investigating team, investigating officer that how to do investigation. Court cannot say like this: these two people filed a protest petition, therefore please don't make the accused of these two persons. It is the wisdom of the investigating team. Anyway, after that charge sheet, the trial continued, and the trial court surprisingly convicted Mr. and Mrs. Talwar. And the prosecution developed a theory. By the way, do you know who, in a criminal case, in whom the burden of proof lies? Do you know the burden of proof?
The accused.
Exactly. Am I right? I responded her accused, and I see no reaction. I responded her exactly.
So the
Yes,
burden
sir.
of proof
Hopefully,
always lies on the
I was
prosecution.
hoping that there may be some reaction.
So the burden of proof is always on the prosecution,
Yes,
unless in exceptional cases where there is a reverse burden of proof.
it is always on the prosecution. Always. If X has committed a murder, it is a matter of common sense. X is not going to prove that he has murdered. Prosecution has to prove that the X has committed a murder. Right? But as you rightly said, there are certain extraordinary exceptions. There are certain circumstances where the burden of proof shifts on the accused. But this is not the general rule, it is an exception. Do you have any idea about any exception?
So matters of sexual offense. But even then, sir, the interpretation is that the prosecution will have to completely prove that there was a chain of events. Only if that chain of events is proved, then you can have a reverse burden of proof.
Hmm. Anything else? No, we are
Shriyapa.
talking about the general offenses. Don't bring the sexual offenses in between. There are also exceptions. I'm talking about every offense, any offense. Any offense provided in the IPC.
So plea of insanity.
Yes. Not the plea of insanity under section 84 of IPC, but the entire general exception. Section 76 to 106.
So, but that's a different burden of proof, right?
Hmm.
He has
Yes.
to prove his case lies in the general defenses. But the burden of proof to prove that he has committed the crime will lie on the prosecution only in that case also.
Yes, 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 yes. The burden of proof is limited, you mean to say. Huh? Well, the accused has to bring his case within the exceptions only.
Oh,
Not
yes, sir.
more than that. You're right. Sure. Okay, I tell you. If in an offense, the situation is like this, that the certain thing is exclusively in the knowledge of the accused, in that case, the burden of proof shifts. It is exclusively only and only in the knowledge of accused. You may be a bit confused. I'm giving you an example. For example, there is a room, and supposing for a while, in that room there is only one entry, no window, no other door, etc., etc. And you have locked two person in that room. two-person enter in that room and you lock that room from outside. The point is, there is no entry in that room except the door where you have locked or where you are standing. Right? After some time, after an hour or 2 hours, you unlock the room, you open the door, and you found that the one person is badly injured, or rather say, is murdered. One of the two-person dies, and he has so many injuries in the head and neck, etc., etc. And the other one has no injury. In this situation, the situation is like this. What has happened in that room? It is exclusively in the knowledge of that person. Which person? The other person, or one person of the two. It is the situation like this, even the investigating officer can do nothing in this unless that person discloses. Right? Do you get this point? In such situations, the burden of proof shifts on the accused, because in that case that person will be made an accused. In general cases, the burden of proof is on the prosecution, but it is an exception. If the situation is like this, the matter is in exclusively in the knowledge or in the knowledge, no other one can tell about that. What had happened actually, except that person. In that case, the burden of proof shifts on the accused. The exact thing happened in the Arushi case. In the prosecution developed a theory, which we were talking about a theory. What was that theory? Theory was this: that there is a house, and it depended only on the statement of one maid. What was her name? Yes, Bharti Mandal. She came in the morning and she stated that the door was locked from outside, etc., etc. So what was the theory? The theory was there was a house, and in that house there were four persons: Mr. and Mrs. Talwar, Arushi, their daughter, and their servant Hemraj. And out of these four persons, two were murdered. The prosecution developed this theory that this is the matter like this, which is exclusively, only and only in the knowledge of the accused. Mr. and Mrs. Talwar can only tell what had happened, nobody else. And the relying on this theory, and obviously somebody daughter was murdered, they may not have, of course they must not have a proper frame of mind. So they, during interrogation, they answered, and some answered were contradictory like this. You can imagine the position of the parents whose daughter was murdered. So there were certain contradictions in their statement, and after that they developed this theory, and on the basis of this theory, they were, what happened to them? They were awarded life imprisonment, both of them. by the trial court. After that, they appealed the case in the Allahabad High Court, and the Allahabad High Court acquitted both of them. And that is, it will take much time to discuss that case. It was just a reference. It was all about the police report, which is known as generally the charge sheet. It may also be final report. And now it's your time. Any question? Yes, please. Tomorrow we are going to begin a new topic, next topic. It's okay. Okay, then see you tomorrow.
Thank you, sir.